Good morning and welcome back to our 11 a.m. panel on Schrems 2. We're delighted to have an abundance of riches on this panel. We have some real our leaders in government on both sides of the Atlantic, and then we have our industry stakeholders. So we're joined this morning by Jim Sullivan, who's Deputy Assistant Secretary for Services at the Department of Commerce, with responsibility for Privacy Shield. Rolf Sauer, who will be joining us momentarily, sitting in for Bruno Giancarelli, who can't be with us today. Rolf is the Deputy Head of Unit of International Data Flows and Protection at the European Commission. And we're also joined by Andrei Jelinek, who's the Chair of the European Data Protection Board. So just to frame the panel, the Schrems 2 decision is the latest and most significant event in a long-running series of issues regarding the appropriate role of surveillance in our society and the inevitable collision of surveillance and privacy. The European Court of Justice, the decision invalidated the EU-US Privacy Shield, raised questions regarding the use of standard contractual clauses, and created new obligations on data exporters. These findings have created uncertainty regarding transatlantic data flows, specifically, as well as data transfers from the EU to certain other countries more broadly. The uncertainty is only heightened by the fact that this is the second time the CJEU has validated a data transfer mechanism with the US. US industry associations have called for immediate negotiations on a successor agreement for EU-US data transfers. So, Jim, let's start with you, and it just take some time, but give us some idea of where things stand and what you perceive, or what's the path forward, since it seems as though there's no quick fix for this because of the government access and national security issues.
So good morning, everyone, and thank you for having me back again this year. Before I respond, I want to make sure folks can hear me. Unfortunately, I had a little difficulty hearing Dan, so before I just start monologuing, could folks let me know if you can hear me clearly? Thank you, Jason. I see you can. Great. Okay. Well, you've set that up well, Dan, from what I heard. I think there can be no doubt that the Schrems 2 decision has created enormous uncertainty about the ability of companies to transfer personal data from Europe to the United States. Of course, the ruling invalidated the European Commission's adequacy decision on the Privacy Shield framework, on which 5,300 companies had come to rely over the past few years. The decision also imposed some new and rather unprecedented obligations on companies that use EU-approved transfer mechanisms like SECs and BCR, standard contractual clauses, and binding corporate rules. Most notably, the ruling requires those companies who use those mechanisms to now verify on a case-by-case basis whether foreign legal protections concerning government access to personal data meet EU standards. In the months since the decision, unfortunately, the lack of clear guidance to date from the EDPB, the inconsistent approaches from European data protection authorities, and the calls, frankly, by some EU officials and some in the Commission for data sovereignty and data localization, again, have unfortunately, I think, added to the confusion that's out there right now. And so, like many others on both sides of the Atlantic, the US government is deeply concerned about the current state of uncertainty around transatlantic data transfers. Many have opined on this, but I think, again, with the dramatic increase in reliance right now on digital technologies in the pandemic and the COVID crisis, the ability to move, to store, and process data seamlessly across borders, quite frankly, has never been more crucial. Cross-border data flows have become utterly indispensable to citizens on both sides of the Atlantic to live, to work, and to communicate. They power our businesses, their operations, their growth, both European businesses and US businesses. And again, those businesses, every size and every sector of the economy. They underpin our $7.1 trillion economic relationship. But again, most importantly, right now, they enable governments, private companies, and organizations worldwide to leverage the data sharing and collaborative research that's really critical to understanding the COVID virus, to mitigating its spread, and to expediting the discovery and developments of treatments and vaccines. And so in view of the crisis created by the ECJ's decision and the urgent need for certainty and legal clarity right now, the Commerce Department, in consultation with the White House and with other federal agencies, is working on a number of fronts. We are convening regularly, if not daily, with industry groups to understand the specific challenges they're facing, particularly those that have been most directly impacted by the ruling. We've issued some updated guidance to the Privacy Shield participants on our Privacy Shield website. And of course, we're engaging very closely with our European partners, both in the European Commission and at the European Data Protection Board, but also in certain member states as well. Again, with the goal of making sure we help ensure trust in the digital economy, just as we had done before, during, and after all three of our successful annual reviews of the Privacy Shield framework since 2017. I want to highlight the August 10th joint statement that was issued by Secretary Ross, my boss, and Commissioner Renders, announcing that the Commerce Department and the European Commission have initiated negotiations on enhancing Privacy Shield in a manner that addresses the court's concerns in the Schrems II case. It's premature for me to provide any sort of timeline on those negotiations, but I do think it's important to note that unlike the original Privacy Shield negotiations back in 2015 and 2016, what we're dealing with and what we're focused on right now is a very limited set of issues that are exclusive to national security. So Privacy Shield's commercial protections were not at all at issue in the Schrems case. And hopefully, given that we're dealing with such a discrete set of issues, that can help move things along in a more rapid fashion. Both sides do seem to be highly motivated, I think, to try to find a solution as expeditiously as possible. For those of us in the US government that are working on this issue, we are especially mindful of the onerous compliance burdens that Schrems II now seems to have placed on companies. We, of course, since we administer the Privacy Shield program at Commerce, we are always mindful that for many companies, Privacy Shield was the most cost-effective and in many cases, the only valid option for a lot of companies, SMEs especially. I think nearly 4,000 of the 5,300 companies in Privacy Shield are SMEs, and most of those simply don't have the capability, the capacity, or the resources to use another mechanism like SECs. And so Privacy Shield, again, was their only choice. Now, for EU individuals, of course, Privacy Shield afforded unprecedented privacy protections and redress mechanisms relating to potential corporate abuses, but also government surveillance of their personal data. And it is worth noting that Privacy Shield's limitations and safeguards in that area on national security, especially like the ombudsperson mechanism, applied to data that was transferred not only pursuant to the framework, but to all other transfer mechanisms as well. I think most of the folks in this audience are probably well aware that our Federal Trade Commission, the FTC, has made clear that the Schrems II decision does not relieve Privacy Shield participants of their obligations under Privacy Shield. FTC Chair Joseph Simons did confirm that the FTC will continue to hold companies to their promises that they've made under Privacy Shield. I know that there have been at least a few commentators who've questioned why would companies want to continue in the Privacy Shield program when the ECJ has ruled that they cannot rely on the framework to transfer data. In our experience, in our conversations and our engagements to date, especially with Privacy Shield participants, most companies do seem to appreciate that ongoing participation does afford at least two key benefits. First and foremost, it would help facilitate their certification once an enhanced Privacy Shield framework were negotiated. And second, it could go a long way in helping to demonstrate their good faith efforts to respect EU privacy norms, at least until EU authorities provide clear and uniform guidance on what measures and what additional safeguards companies need to adopt to comply with the court's ruling when they use SECs and BCRs. At the end of the day, our view is that it should ultimately fall to governments, not private companies, to address the types of national security issues that were addressed in the Schrems II decision. Just like European nations and other countries around the world, the United States does conduct intelligence gathering activities to ensure that national security and foreign policy decision makers have access to timely, accurate, and insightful information about the threats that are posed by terrorists, by criminals, by cyber hackers, and other actors. Particularly in view of the extensive U.S. surveillance reform since 2013, however, the U.S. legal framework for foreign intelligence collection provides clearer limits, stronger safeguards, and more rigorous independent oversight than the equivalent laws of almost all other countries. Now, that having been said, the ECJ did issue its ruling, and it's now up to our two governments to address that ruling and the uncertainties that it has generated. And despite our different legal approaches, the US and the EU do embrace common values with respect to individual privacy and data protection. And as like-minded democracies who are both committed to the rule of law, we have managed to bridge our two legal systems before. But I do think that now more than ever, our obligations to protect and improve the lives of our citizens, again, our mutual respect for privacy and data protection, and frankly, our collective advancement in industry and science really do require us to take pains to bridge our respective data protection regimes once again, and really provide the legal clarity and certainty that is needed right now and that is essential, frankly, to transatlantic data flows. So I'll stop there and thank you again for the chance to share my views and look forward to the conversation.
Thank you very much, Jim. Thanks for a really in-depth opening. I think you've framed it well. Andre, let me turn to you. I don't see Rolf. I'm hoping he can join us midstream. But for your comments, I know on September 4th, the EDPB announced that you've established two task forces following the judgment of the ECJ in the Schrems II case. Tell us a little bit about where things stand with the EDPB and sort of what your work is right now. Contending with the challenge of Schrems II.
Thank you, Dan. Thanks for inviting me here and that I have the opportunity to join this panel. I really want to jump in, but I want to reassume again what the EC Court of Justice ruled, like James already said, and he's quite right. We will have to take pains to bridge the gaps, and I cannot more than agree more that we are both democracies, the EU countries and the United States of America, and we have to follow the rule of law for sure, and we have to follow the judgments of our highest courts. And so, as you are aware, the Schrems II judgment ruled the EU-US Privacy Shield invalid with immediate effect, like James already noted. This invalidation echoes some of the concerns the EDPB has repeatedly voiced in the framework of the annual review procedures of Privacy Shield, but we also acknowledged during these annual reviews that there were made progress. Next, the court ruled standard contractual clauses valid as a transfer tool and specified that controllers must assess the specific context in which they are used and the legislation of the third country to which data is transferred. If the recipient of the data is unable to comply with the standard contractual clauses because of competing obligations to which it is subject under the third country's law, exporters and recipients will have to assess if adding supplementary measures of a legal, technical, or organizational nature would be able to compensate and ensure a level of protection of personal data essentially equivalent to that guaranteed within the European Union, the EEA. If so, they may then be able to proceed or continue transferring data to the third country. The judgment is a strong reaffirmation of the principle that the protection of personal data from the EEA must travel with the data when it is transferred to third countries, so that the protection is truly effective. National legislation may limit the exercise of fundamental rights for certain purposes, such as national security. However, the legislation must clearly specify the circumstances and the conditions in which measures interfering with the right to data protection may be applied. This is to ensure that they are only applied when they are strictly necessary and in a proportionate manner. Legislation must also impose some minimum safeguards to allow those persons whose data has been transferred to have sufficient guarantees to protect their data against the risk of abuse. While being a strong reaffirmation of the principle of data protection in the context of international transfers, the judgment also raises many questions among companies who need legal certainty when transferring data outside of Europe, as James already noticed. Many businesses rely on standard contractual clauses to transfer data to countries outside the European Union. The ruling has a far-reaching effect on these businesses, giving controllers an important responsibility while also putting a major obligation on the shoulders of data protection regulators. The judgment provides that this primarily the responsibility of the controllers to assess if the standard of essential equivalence can be met for a data transfer in a third country through the use of SCCs or other transfer tools and supplementary measures. Controllers have the obligation to suspend or end the transfer according to the judgment if they conclude that it cannot meet the essential equivalence standard or notify their data protection supervisory authorities if they intend to continue transferring data. Competent supervisory authorities have the task to suspend or prohibit a transfer of data to a third country pursuant to SCCs if the protection of the data transferred cannot be ensured by other means. This is in particular so where the controller or a processor has not already itself suspended or put an end to the transfer. Given the important new responsibilities for controllers, the European Data Protection Board has immediately taken action following the ruling. Already in July, on July 23rd, I think, the EDPB, we issued preliminary guidance for stakeholders in the form of a statement and a frequently asked questions document. The EDPB will continue its work in relation to this judgment and prepare additional guidance. And as Dan already mentioned, during the first plenary after the summer on September the 2nd, we created a task force that will develop additional information and recommendations for controllers and processors. This information should help, and I'm sure will help controllers and processors in identifying and implementing appropriate supplementary measures of a legal, technical, and organizational nature that could allow them to meet the essential equivalence standard in some of their data transfers to third countries. As we do for our guidance work, we will listen to stakeholders to make sure their questions and concerns are addressed to the extent that is possible. We will also review and update, where necessary, existing EDPB documents that are relevant to data transfers in accordance with the judgment. It is important to note, however, that there cannot be a one-size-fits-all and quick fix solution. As James already said, this will be they already started to negotiate, but it will last some time. Each organization will need to evaluate its own data processing operations and transfers and take appropriate measures accordingly. We, the EDPB, stands ready to provide the European Commission with support and assistance to build, together with the United States, a new framework that fully complies with EU data protection law in line with the judgment of the court. It is with this in mind that I'd like to thank the organizers of this annual Data Privacy Conference. It is precisely through conferences like these, which bring together both sides of the Atlantic, that we can reach a deep understanding of the implications of the court's ruling and of the challenges of protecting data protection in today's hyper-connected world. I look forward to our discussion and to hear from our counterparts how they see this unfolding in the near future, and I'm looking forward to the discussion. Thanks.
Thank you, Andrea. As a follow-up, Andrea, I just wanted to you mentioned the task forces and the announcement of guidance, both to the commission, to DPAs, and to industry. Do you have any timeline or timetable in terms of when that guidance might be issued?
We're working as quickly as possible and as thoroughly as possible. It also needs some time, but I'm very positive that it will be there within the next 2 months. I hope, but I don't want to promise you more than I'm able to promise, because I don't tend to be over promising. I really try to be very clear, and I hope it will be there within the next 2 months for an open discussion with the stakeholders. If we come to a conclusion, then we will set this on the website, and the stakeholders will have the opportunity to take part of the discussion.
Thank you. That's very helpful. Just even a general sense of timing is helpful. I don't see Rolf from the European Commission. I suppose he was having technical difficulties. So why not at this point, let's turn to our stakeholder reaction and our industry panel. Let's bring them in, and I'll do quick introductions, and then we'll turn it to them for their remarks. So for this section of the panel, we have three respondents. Sarah DePaul, Associate General Counsel and Senior Director for Technology Policy at SIIA. Welcome. We have Gabriela Zanfir Fortuna, Senior Counsel at the Future of Privacy Forum. And last, but certainly not least, Jason Albert, Managing Director, Public Policy at Workday. So Sarah, why don't you've heard Jim and Andrea, your members are knee-deep into this, and particularly, I know you have a concern about SMEs, something that Jim mentioned, but give us your reactions and take a few minutes to let us know, how this is impacting your members.
Sure. Thank you, Dan. I'm really happy to be here today to share SIA's views on transatlantic data transfers and to reiterate our support for the ongoing US-EU dialogue on how we can set forth both technical and political solutions to the questions that were raised in the Schrems II case. I just briefly want to give a little introduction to my organization, SIA, for anyone who's not familiar with it, just to give some context to my comments and the views that I'm going to share today. We are the only trade association that represents more than 700 companies across the global information industry. Our members reflect the broad and diverse landscape of the digital information age, and this includes both B2B and B2B services, from small and specialized firms to the large multinational industry leaders. And it represents firms across finance, education, health, technology, and specialized content and publishing. It can be a little challenging to represent such a diverse group of members, especially when our policy positions are based on consensus. But one issue that really does unite across our membership is the necessity of the free flow of information, including the ability to transfer personal data across borders. And the ability to engage in these data transfers, particularly from the EU to the United States, is critically important for business operations and the delivery of goods and services to consumers, European and American alike. I think I would like to start by reiterating that the Schrems II decision ultimately upheld the validity of standard contractual clauses for data transfers. And of course, this decision was premised on the requirement that companies engaging in these transfers be able to certify the adequacy of the receiving company's privacy laws, or at least have the ability to provide additional safeguards to guarantee adequate protections. The prevailing assumption, however, must and should be that technical safeguards can be implemented and that data transfers from the EU to the US are legally valid today. Having said that, we are concerned about the potential for an erosion of the mechanisms that facilitate data transfers from the EU to the US, and indeed from the EU to anywhere in the world, particularly as we're hearing more and more calls for data localization. Setting aside the enormous impact this would have on trade and our political relationships and just the day-to-day lives and the business of Europeans, I want to highlight some of the practical consequences of the situation we're in today. First, businesses, many of which are small businesses, and we have many small businesses within our membership, are now charged with an obligation to assess privacy laws, often of a foreign country, to determine whether or not an adequacy determination can be made. And this isn't a matter of a company looking to one law to assess if it meets a set number of explicit standards. This is a complex legal analysis of privacy laws, plus any law that can intersect with it, including national surveillance laws. That would be a feat for even the largest multinational companies that have enormous resources to put to sophisticated legal counsel to help with those decisions. But this is now an obligation that any business that is engaged in cross-border data flows outside of the EU must be making. And this is a misplaced burden, and it's one that our governments can help solve by continuing their negotiations to revise and refresh the Privacy Shield framework and to develop technical solutions to address any viable concerns with US adequacy through model safeguards or some similar guidance. Second, this is not just a big tech problem. Businesses of every size and in every sector, from manufacturing to telecommunications to medical supplies, have to respond to the evolving standards and would be in an impossible position if the worst were to happen and the viable transfer mechanisms were eroded. Businesses today operate in a global market. If the mechanisms for transferring data erode, they are going to be in a position where they have to choose either to respond to the technical and operational necessities of running a business that reaches a global market, and doing so possibly in violation of a DPA finding and EU law, or pulling out of the European market altogether. This is going to affect Europeans and Americans alike. As just one example, from the European perspective, should these transfer mechanisms erode, a telecom provider in France could not offer roaming services to its customers traveling to the United States because it could not transfer customer information to US partner providers. I don't think that's an outcome that we want to see happen. And lastly, we are risking a global system of data localization, and that is just bad for economic development, it's bad for privacy, and it's bad for customers. Forced data localization harms businesses in every sector, and it stifles trade. The inability to move data freely across geographies impedes operations, it reduces efficiency and productivity, and it imposes significant costs on companies. Data localization often is considered to be protective of privacy, but that's not the case. In fact, localization requirements actually increase data security risks, privacy risks, and costs. Indeed, the US Federal Trade Commission and the European Commission have publicly warned against data localization as a method for protecting user privacy. Compliance with the law and company accountability towards the user are much more effective ways to achieve and safeguard user privacy. All of the incentives are in place for the EU and the US to work together to identify the technical and political solutions to the questions left by the Schrems II case. In our view, this should include the EDPB identifying technical solutions by guidance and model safeguards to help companies meet the standards set forth in Schrems 2. We understand this process is already underway. We think the US government can and should help with this by providing the EDPB with the information on US law, including national security laws, which many commentators have noted was not fully addressed by the CJEU opinion. EU policymakers should help DPAs increase their competency on the complex issues affected by their case-to-case adequacy determinations that will have to be made, including economic and trade considerations. The United States should pass a national privacy law. While this will not address the Schrems 2 issues directly, having a consistent national standard when addressing global issues, such as how we can safely transfer data from a foreign jurisdiction into the United States and vice versa, will be helpful. Moreover, both the EU and the US need to work toward political solutions to the data flow question, including what rights and obligations they must and should meet toward one another's citizens. I note, for instance, that the redress right that sits at the heart of the Schrems 2 case is not a standard that any EU member state, to my knowledge, can meet for a foreign data subject. And it's not a standard that any country that has an adequacy determination from the European Commission can meet. And so this is a larger question that is going to have global significance as we weigh it within the context of the Schrems 2 decision. Thank you.
Thank you, Sarah, for a very strong intervention. Gabriella, let's turn to you. Your work on behalf of the Future of Privacy Forum, and also your academic background. You've been thinking about this for a long time. So please, weigh in and let us know what your sense of the implications and sort of, where do we go from here?
Thank you very much, Dan, and hello, everyone. Thank you so much for the invitation to share my thoughts after thinking through this judgment for the past couple of months. And I'm so thankful, Dan, you mentioned my academic background, because my plan for today is to be academic and a bit provocative and say bluntly that the consequences in practice of the Schrems 2 judgment could potentially break the internet. And I think I've got your attention now. And I know that there is going to be pushback to what I just said, but I also think there is not a sufficiently clear understanding out there of how broad the concept of a data transfer is within EU data protection law, nor of how narrow Article 49 derogations are construed by the GDPR itself, even leaving aside EDPB guidelines. Just think about the fact that even providing access to EU-hosted data from a third country, for instance, for administration purposes, counts as a transfer, as most recently showed in the EDPB Q&A document published immediately after the Schrems 2 judgment, and that Andrea just referred to. I also think there is not a clear understanding of how limited the possibility to lawfully transfer data from the EU to the rest of the world is right now, all the more so for transfers from the EU to the US. And I refer to the US since the Court of Justice actually made specific findings about specific features of US law, leaving limited room for additional characterization by private companies in their own eventual transfers impact assessments. But the way the judgment is construed has significant consequences on all data transfers to all third countries. And let me explain why, because in my view, the most consequential finding of the Court of Justice in this judgment for the long term is not necessarily that the Privacy Shield was invalidated or that the SCCs are valid, but it was that the level of protection of personal data in the country of destination must be that of essentially equivalence, also for standard contractual clauses, and generally for the additional safeguards as referred to in Article 46, paragraph 1 of the GDPR. Now, essentially equivalence to that offered in the EU is a high bar, which was understood before this judgment on the basis of the language used in the GDPR to only apply to adequacy decisions. And it makes sense for adequacy decisions to be conditioned by an essentially equivalent level of protection, because an adequacy decision means that data flows can happen undisturbed between the EU and the third country, no other authorization needed, no other prior assessment, and so on. But through this judgment, and again, I cannot emphasize this enough, the court raised this bar for all the safeguards. Now, achieving essentially equivalence in all third countries where the data is transferred through mechanisms that are outside of the commitments, competences, even powers of public authorities in that legal system is very complicated in practice. And one has to question whether this is even possible. But we do have an answer in the judgment because the Court of Justice believes it is possible. Otherwise, it wouldn't have decided that SECs are a valid mechanism for transfers, even if they absolutely cannot bind public authorities in any way, as the court highlights in the judgment. Now, the logic of the judgment shows that the court believes SECs can achieve essentially equivalent data protection in a third country, even without binding public authorities. But it nuanced this finding a lot, saying that it will always depend on the circumstances of a particular transfer. And when SECs are not sufficient to achieve essentially equivalence, the court found that supplemental measures, which frankly I think refer to an extra-contractual measures or measures of an extra-contractual nature, but also they can bring additional safeguards that will complement SECs for those particular transfers to bring them to the level of protection. And I think this finding of the court is, actually what makes it difficult for DPAs to provide clarity and guidelines quickly. And I fully understand why this process takes quite long. And applying in practice this high bar of essential equivalence to virtually all transfers to all third countries and to a broadly understood notion of transfers, just as we've heard from the speakers before me, can have major consequences on daily activities of Europeans. And to conclude, I would just like to invite everyone listening to take a couple of steps back from the minutiae of the judgment that I just went through, and to see that the actual problem the court puts at the center of its judgment relates to proportional government access to personal data, independent oversight of that access, and individual effective remedies for the persons concerned. Now, this should not be extremely controversial requirements of jurisdictions that are rule of law. However, they are a Gordian knot in this debate because due to their very nature, they are not a problem that can sustainably be solved by private companies. And they should under no circumstances be solved by pushing individuals to consent. And this is why I believe the long-term solution, the sustainable solution, to prevent this potential data cold war is in the hands of governments that share the same democratic values and that treasure rule of law. It is not something that companies can solve, and it is not something that should be pushed to individuals to consent to, because I know this is not the outcome that data protection law is supposed to achieve. And I'm very curious to hear reactions from the panelists and from the public that's watching us. Thank you.
Gabriela, thank you very much for a very provocative and well-considered intervention. Jason, let me turn to you, and then Rolf, I'll bring you in after Jason. But Jason, I know on behalf of Workday, you've written quite a bit on standard contractual clauses and the need to update SECs. So why don't you take a couple of minutes and let us know your views on where we go from here and what, if anything, or any reactions to anything that you've heard.
Well, thank you, Dan. Again, really appreciate the opportunity to participate today as part of this really interesting discussion. As Dr. Jelinek mentioned, and as Gabrielle and others mentioned, I think we start with the idea here that while Privacy Shield was struck down, that standard contractual clauses remain valid. And it brings up sort of a very interesting point, which is that a lot of times when we think about data transfers, whether to the US or elsewhere, we think about sort of all or nothing, right? Because it's either the data is subject to surveillance laws that aren't seen as compatible with European principles, or they aren't. But the fact is that different types of data pose different types of risks of access. Right. Intelligence authorities really are interested in communications and social media because they relate to the types of things that they're interested in, and the types of things that they want to investigate. There are lots of companies, perhaps the vast majority of companies, who've never gotten a FISA warrant, have never gotten any sort of national security request, and won't, because the type of data that they transfer just isn't interesting to that purpose. And so one of the nice things I think about the ECJ's decision is that it really focuses on a case-by-case analysis. And it says that, yes, you can use SECs for transfers, but you have to think about what protections are in place. And I think, again, Dr. Yelling did a great job of talking about, some of them are contractual, some of them are technological. Increased use of encryption is a great example, particularly for data in transit. You can give increased commitments to the data importer about how you might handle a request if ever you received one. But I think it also has to take account of the type of data and the risk of access. Because again, different types of data pose different risks of access, and at the end of the day, it is what we're trying to do is protect data subjects' rights here, and to take a proportionate view of that. And so, from our perspective, looking at the court decision, transfer to the U.S. remain possible, as we've discussed. It's important to take a case-by-case approach, looking at both the protections for the data, the risk of access. And again, I think this is very clear in the guidance so far from the European Data Protection Board and its FAQs. And then, of course, it's important to move forward. We're very supportive of the efforts of the European Commission and the Department of Commerce to enter into discussions about how to move forward in Life Assurance 2. An overarching mechanism for data transfers like Privacy Shield and Safe Harbor before it, I think, are important, even though SECs remain valid. And there are a number of steps that I think should be on the table as we think about that. We had the ombudsperson under Privacy Shield. The court said that wasn't independent, but you could imagine creating an independent regulator that isn't subject to political control to address complaints in a way that doesn't necessarily require recourse to the court system, which is really hard in the U.S. system. You can codify a lot of protections. We talk a lot about PPD 28. I know Cam Carey in various forums has suggested codifying that. I think that would be a great thing to do. And some combination of these measures, looking at different types of data and their likelihood of access, could provide a mechanism for a sustainable, lasting mechanisms for data transfers from the EU to the US. So again, really appreciate the opportunity to share those thoughts. Look forward to the discussion, and it's been a great panel so far.
Thank you, Jason. Thanks for especially highlighting the national security aspect. Rolf, let's bring you in to the discussion. I know that during the Libe committee hearing on September 3rd, Commissioner Renders said that new standard contractual clauses might be available by the end of 2020 at the earliest. Talk a little bit about the process that you're involved with at the Commission. Andrea mentioned her work with the EDPB, but talk a little bit about your work with the member state DPAs and the EDPB, and sort of further coordination across the EU.
Yeah. First of all, can you hear me? I had lots of trouble, and that's why I've also missed actually most of the interventions of my colleagues on the panel. So which poses a certain risk of repetition. But just so now at least audio is fine. I'm just
You're fine.
Okay, fine. thank you very much. I'm happy to share some thoughts on that, and in particular what we are doing as regards the modernization of the standard contractual clauses. And then, of course, we are also participating in the discussions at the level of the EDPB. You might know that we are a member of the EDPB, although a non-voting member. So we bring ourselves to the table, but the ultimate decision, of course, is for the data protection authorities to make. But we will participate in this, and I think we cooperate very well with them. And that we will also do this, obviously, for the guidance that the EDPB is developing. And I can say on this that I'm actually seeing quite good developments there in terms of the new drafts that are developed through the task force that the EDPB has created for sort of applying for developing guidance for applying the judgment. So and this will be extremely important. Obviously, this has to be closely aligned, this work, with the work that we are doing on the modernization of the standard contractual clauses. This modernization exercise is not just about, by no means, just about the question of access by public authorities to personal data. This is something which, irrespective of the Schrems judgment, we wanted to do, we needed to do. As you know, the standard contractual clauses, they date from different times, starting from 2001 and then 2004 and 2010. So some of them are probably a bit outdated in terms of addressing the needs of the modern digital economy. Of course, in the meantime, we also have a major change in law with the GDPR. So that's something which needs to be reflected. Not that this means that everything is new, but still, it's something that, of course, we have to address. Also update the standard contractual clauses in that regard. And then the last point is indeed that of government access in the third country. So we are engaged in this work for some time. First of all, as I said, to really see what needs to be changed to make this a useful tool for companies for data transfers, to address all transfer situations, because currently not all transfer situations are covered, and we want to do that. So we have gone through an independent study that has conferred with business, has sought the information, the input from business to see what they think about the current SECs, what is missing, what is not going well, but also what is going well. So we have taken all this into account, and we are quite advanced in this. But of course, we had to wait for the Schrems II judgment to see what the court would decide on standard contractual clauses. I mean, aside from the many, let's say, issues that the judgment certainly raises, I mean, one, let's say, positive aspect at least is that it has declared the SECs valid, and in that context has looked at the, let's say, procedural mechanisms that the SECs contain for dealing with government access. I'm not disputing that this it hasn't raised new issues that are difficult on the assessment side in particular, but at least it has confirmed that some of the mechanisms in terms of the importer cooperating with the data exporter, both of them cooperating with the data protection authorities and things like this, that this provides a framework to address the issue. But of course, we now need to see, and I think that's where the focus has to be, how to apply this judgment in practice, and that's where the guidance comes in, and that will have also a certain impact on the design of the standard contractual clauses. I think you have to see that there's probably certain things certain consequences from the judgment that we can address through the standard protection clauses, but those are model clauses, and some of the things that the court requires are case by case. So there are certain elements which you can maybe frame within the model clauses, but you cannot address and totally determine through the model clauses. So we are also trying to find the best dividing line between what should be in the clauses and what is rather than which should be clarified through guidance. I think on the aspects that now will concern operators, data exporters in particular, when they use standard protection clauses, I think, although I missed most of this, I believe that Andrea Jelinek, but also Jason have already spoken about this. I think it is indeed very important to not forget that this is a case-by-case analysis, that this is not an adequacy, sort of a mini adequacy finding that each company needs to carry out. It has to focus, and I'm not saying that this is easy, but I'm just trying to still explain that it's maybe a bit less than some people think. Companies have to focus on what is in terms of third country legislation relevant for their transfer situation. So in terms of the personal data they transfer, in terms of the recipient of the data, have to see whether they even fall, for example, within the scope of application of certain laws that they would then have to further assess as to, against the criteria set out in the judgment. And then there is, of course, the question of supplementary measures, which I'm sure was also addressed already. I think I've seen in the discussion already that a number of interesting, ideas have been floated. Some of them are more procedural. Some of them are more, let's say, substantive, if you wish. Encryption, which you always hear, is certainly one element that will play a role for certain types of let's say access problems, but it's not the solution for everything. So we, as I said, we will participate in this discussion, and as I said, I see that there is now a lot of work put into this by the European Data Protection Board, which I think is extremely important and welcome. And we have to some extent wait what comes out of this discussion, and then we will have to see. I hope this will be then sort of crystallize itself in very practical guidelines that leads companies step by step through what they have to do and which tools they can use to deal with certain types of situations. So that's what we would hope is the outcome of this. It takes a bit of time. It's not an easy judgment to address, to deal with. But I also wanted to say, because that's one thing I heard when I connected, this is a constitutional judgment. It comes from our highest court. It applies the Charter of Fundamental Rights. So our fundamental rights treaty that we have, and I disagree with the characterization as this being something which we apply to, or the court wants to apply to third countries, but not to the European Union. I think that's a mischaracterization. As Gabriela has I think well said, we're talking here in the end about basic requirements of the clarity of the law that should frame the actions of the executive. We're talking about necessity and proportionality. Those might not be the words used in other jurisdictions, but other countries have concepts like reasonableness, which probably go in the same direction as proportionality. So it's something which I think are global principles. And then it's about effective judicial redress, which, as Gabriela said, should not be controversial. So I also wanted to really underline this. We have full understanding for this being a difficult task for companies, but I think we should at the same time be cautious in criticizing what the court has ruled, because, as I said, I think those are basic requirements, and I would hope, that's my last word on this, that it will also trigger a more global debate, and it has to some extent already done that, a more global debate on what should be the standards for government access. There is now some work being carried out at the level of the OECD. There might also be some work being carried out at the level of the Council of Europe. And I think that's a good thing, that this discussion is picking up again. There was a discussion at a time, basically at the time of the Snowden revelations, I think, when the United Nations started working on this, and especially the UN Special Rapporteur for Privacy. But unfortunately, this has been a bit overlooked and forgotten. I would almost say, and I think undeservedly so. And I think it's good that this is now again on the agenda. And if we develop there certain standards, that might also help to contribute to facilitating data flows. Thank you.
Rolf, thank you very much. We've got about 15 minutes left for questions, and so we see some good questions that are beginning to come in. Let's kick off. There's a question from Anne Vroom, and she said, so with regards to Schrems 2, is the bottom line that companies should just keep on doing what they're presently doing until they are advised differently? I'll throw that to the panel for reaction or comment.
I'm happy to get us started. I mean, companies have been advised through the opinion that something different needs to be done with respect to cross-border data transfers. The open question for companies as they try to innovate ways to apply the CJAU's opinion on a case-by-case basis is what will be sufficient to meet what a DPA will deem as an appropriate safeguard or technical solution. So at a minimum, companies need to be conducting transfer impact assessments and understanding the data that is subject to the transfers that fall under this opinion. And they will need to assess their risk for the types of national surveillance data collection that was addressed by the opinion. And to the extent that there are risks, they're going to have to look at how they can implement technical, contractual, and other legal safeguards to meet the holding in that opinion. And that is being done. It's just at this point, it's not clear where risks may lay as companies are innovating ways to respond to this without guidance. But we know guidance is forthcoming, and that will be helpful in solving some of those open questions.
Andrea, yes, please.
I'm quite sure that the companies should not wait until they are advised differently, because the court told the companies in its decision, in this ruling, that it's up to them to decide and to look on a case-to-case basis on their data processings and on their transfers. And if they are not sure what to do, I think it's quite important to know they can't just work like every day, like before the 16th of July, because the European Court of Justice ruled quite differently. But if they already started to look into their processings, into their transfers, and I'm sure many of the companies already have quite a lot of ideas, and the ETPP already made the FAQs in July, and we are providing the future guidance. And we are also looking in a case-to-case on a case-to-case basis. And if there are complaints, we are also investigating on a case-to-case basis. And this takes time. And you can be confident if you go to your national DPA in Europe, if your controller is going to their national DPA in Europe, they will assess the case with them, because if you have doubts, or if you have doubts to ban or to stop the transfer, the court ruling also say you have to go to your national DPA. And I really want to underline what Gabriela already said. The court raised the bar of the essential equivalence, but we will meet it together to jump over this bar, because we have to jump together over this bar, because we are both, and not only Europe and US, but all the democracies have to jump together over this bar. And as Ralph already said, this discussion about the standards for government access is now a worldwide discussion, and we also will have to bridge the gaps. This is just the try of an answer for Anne and Vroom.
Dan, if I could just add one thing really briefly there, which is one thing we've seen a lot is people doing transfer impact assessments, just like we do privacy impact assessments. And I think it's important for any data controller to do it. And for a company like ours, it's a data processor, to provide the right information in response to that. Certainly we have not stood still in light of the court decision. We've focused on, reemphasizing our encryption, strengthening our already strong policies around how one might handle any type of request if one were ever to come in, and then looking at what additional assurances we can provide. So I think all those points that Dr. Jelinek and Sarah mentioned are all important.
Thank you. So let me turn. We have an excellent question from my good friend Jonathan Cave. Jonathan's a fellow at the Alec Turing Institute. Would anyone on the panel care to comment on the implications of Schrems II for free trade agreement negotiations, especially digital trade, but not exclusively? Is there active coordination between EDPB and parallel U.S. entities and the trade negotiators? Anyone want to take that? Or did Jonathan stump the panel?
Yeah.
Can you hear me?
Yes.
I'll defer to Ralph on this. My impression and understanding and experience to date has been DG Justice and the Commission has always resisted addressing these sorts of issues in a trade agreement. I think we'd certainly be more than happy to explore that possibility, but of course, I can't speak on behalf of the Commission, so I'll turn it over to Ralph.
Yes, that's indeed correct, that we believe that when it comes to personal data, a trade agreement is not the instrument where we would want to address data flows. That has to do with the fact that this is protected in the European Union, as in many other countries, as a fundamental right, and we don't think that it's appropriate to then regulate an important aspect of data protection, which is the flow of data to a foreign country in a trade agreement. That being said, first of all, we have other instruments to deal with data flows, and they remain available despite the judgment. And I think we have certain aspects that we do that we are ready to address in trade agreements, and that's particular data localization, because I heard that's also, I think, a concern that was expressed on the panel, that this should not sort of usher in an era of data localization, and that is certainly the position of the EU, that it should not. And that hasn't changed through the judgment. We believe in data flows. We are dependent on data flows. We're an export economy, and probably one of the biggest data exporter in the world. So we will not take this as a basis to localize. Whether certain companies might take that decision on a commercial basis, that's another question. But that's not something that we sort of support, encourage. What we need to ensure rather is that we ensure the continuity of protection when data goes out of the European Union. Having a clause in a free trade agreement which says data shall flow freely without anything, let's say, connected to it, which would ensure that continuity of protection, we don't think is the answer to that. So that's why we would indeed think that there should be other channels. There is one international agreement on data protection, which is the Council of Europe Convention 108. That's maybe something which could be a basis for working together in a multilateral setting, also on data flows. And beyond that, we certainly are willing to work on certain instruments that could facilitate the flow of data across borders, even when there are differences in the privacy frameworks, at least. And I would say the model clauses are one of these instruments, but also other things like certification mechanisms or codes of conduct. So I think those are for us the better instruments, because they then specifically address the data protection issues.
Thanks. Sarah, Gabriella, you want to weigh in on that?
Not specifically on the trade agreements, but I just want to emphasize one point that Ralph made just now, that data protection law in the European Union and the rules on transfers are not meant to achieve data localization. On the contrary, I don't think data localization has a part or role to play in data protection, in fact. And the rules of transfers are actually there to precisely facilitate data flows. So I think we should work together to avoid the opposite effect, having the rules of transfers blocking data flows when they are meant to be a vehicle to transport data from Europe to outside of Europe, but in a protected way. So I just want to emphasize that, and I hope we can all achieve that goal.
All right. Andrea, we have a couple of questions that have come in for you. Let me just read. There are two of them. One is from Lynn at SAS. She wants to know if there are any rough guidance. I'll just read both of them, then you can respond to both. Any rough guidance on how EU controllers and their US processor counterparts should provide supplementary measures in this interim period before task force guidance would be, much appreciated. And then the other question is from Heidi Sass, who wants to know what is the NOYB 101 complaints task force? What's it hoping to accomplish? So maybe take those in order.
Thanks for both questions. I think I included already the answer for Lynn in the answer to Andrew, because I addressed these additional measure issue, how they could do it and what they can start to do, and I'm sure they already started to do, to think about their supplementary measures. Because if there is the first draft, and if we come to the end of our first thoughts about the supplementary measures, we are going to speak with the stakeholders, and I'm sure they don't start from scratch when they see our additional measures, our proposals for the supplementary measures. I'm sure they don't start from scratch, and they're already thinking about. That's the answer to the first question. And the second question, NOYB 101 complaints is the second task force the ETPP established on September the 2nd. I'm sure everybody knows that NOYB is none of your business and is the non-governmental organization founded by Max Schrems. This NOYB has filed 101 complaints to all of our EEA supervisory authorities with different controllers from EU exporting, transferring data to the US. And as they are all quite the same, and I can say this because NOYB put this on its website, we decided to create a task force to work very, very close together because I think it's quite important to work even more in cooperation than we did until now. And I think this 101 complaints is an interesting challenge to work on that.
Thank you. I'm going to take the moderator's prerogative and ask a question. There's been lots of discussion among the panel about the need for comprehensive federal privacy legislation in the U.S. And we've been working on this for 20 years, and I'm optimistic that we're it's become a strategic issue, a top priority issue, and I'm hopeful that we can actually get to a comprehensive federal bill in the U.S. But everyone on this panel recognizes that the comprehensive federal privacy law is not going to fix the problems of that have been created by Schrems 2. So my question really is, I know as in the work when the safe harbor was invalidated, creating the privacy shield, there was also work in the high-level working group, which was adjunct, to Privacy Shield, but a separate agreement, led by on the U.S. side, state and justice, the umbrella agreement around law enforcement and sharing information. Is there any? And Jim mentioned in his opening remarks about how this is really a national security issue that we're trying to solve narrowly. But are there any lessons learned from that 2016 agreement, the umbrella agreement relating to law enforcement, that could be juxtaposed into trying to fix the problem that's before us? Any takers on that?
I think Jim is talking, but the mic is off.
I think you're muted, Jim.
Now, I think I got most of it, but unfortunately, I've been having audio problems throughout this session. Could you just, the bottom line question you asked, because you cut out a bit at the end.
Asking, the bottom line question is are there lessons to be learned from the umbrella agreement in 2016 surrounding law enforcement to solve part of the national security problem created in Schrems 2?
Yeah, I mean, I don't want to go too far down this road without guidance here, but obviously the Judicial Redress Act, there's the Cloud Act, there's a lot of conversations around these related issues right now. Ralph, if I heard most of what he said, I think earlier, alluded to some ongoing efforts, particularly in the OECD, around government access to data. One of the other things I'd like to mention, Ralph and I have both been at the table over the past 18 to 24 months on some trilateral discussions with Japan, the EU, and the United States. One option could be, again, alluding to my earlier statement, because the commercial aspects or components of Privacy Shield were not at all at issue. There's no question about there being a problem there. And given the fact that the EDPB is taking up, for example, the issue of codes of conduct. And we have examples of that, like we had with Privacy Shield, but we've got the APAC cross-border privacy rules. Perhaps you take these, this is hypothetical, but if we've got general consensus around commercial protections, and we're working in fora like the OECD on principles on government access, where the democracies and like-minded countries who share the same common values but maybe haven't fully converged on the details can continue to develop principles that govern those protections, that might be one avenue. And we need to make sure that we have the right interlocutors at the table, since obviously, at least on the European side, obviously national security is a remit of the member states. And so they would have to be at the table as well to have a fulsome conversation and address these issues in a really comprehensive and informed way.
Thanks, Jim. Rolf?
So the OECD, not just to say at the OECD, it is of course the member states. No, the European Union is not a member of the OECD. It's our member states. So they are represented there, and they will bring themselves into the table in the discussion. So that I think is ensured. It's correct. It's a prerogative of the member states in the EU. On what Jim said, I mean, we are in these discussions because we agree on this, that we should see how we can develop transfer tools that work as global as possible. The issue is it's indeed certainly because of the judgment, but I mean in a way this was clear already since the first Schrems judgment. It is of course also linked at least to the question of what we do with respect to public authorities. So indeed we need to solve both issues or address both issues to the extent we can. But we are with the US on this and with our Japanese partners. On the umbrella agreement, just very briefly, I mean, I think it's a bit difficult to compare, no, because the umbrella agreement, at least in its sort of what it mainly addresses is exchanges between authorities for data. So there's a specific redress mechanism. Indeed, Jim mentioned the Judicial Redress Act, which implements one important provision of the umbrella agreement. There's probably the question, and then that was the question raised before the court: how do we ensure judicial redress or a form of independent review also for national security? So what is the forum to do this, and how can we ensure that individuals can effectively make use of these tools? Because that's I think one important aspect of you first have to know at least that you have been subject to surveillance. Certainly, if you have strict standing requirements, then you need this if you want to go to court. Otherwise, we have to find other solutions that are, let's say, of an equal independence for adjudication, and where the way to get to adjudication is made sufficiently easy for individuals. So I'm saying the umbrella agreement is certainly an interesting example of how the US and Europe have shown to be able to bridge their differences and find a way to exchange data, and we hope that of course we can do again the same for the commercial side, and we are in contact with our US partners to find solutions to find a more permanent solution for data transfers across the Atlantic. So
right.
That's I think all I can say.
Rolf, well, thank you very much. We've come to the end of our panel. So thanks to all of you for just a terrific discussion. Rolf, I'll pick up on what you said right there at the end. I mean, we're all optimistic that we can work through a solution, and we look forward to having this panel again next year when we hope farther down the road. So thank you very much for your time, and we appreciate all your hard work and interventions. So now I'm going to turn it back to James, I believe, for an address from Senator Cassidy. James?